Welcome, I am the Loud Little Ducky. We are going to be going over Echard's attorney's fees that Woodnick submitted for Laura Owens to pay up for her not so great behavior. So we're going to go over these. That way we have this video to go with our playlist. In the Superior Court of the State of Arizona, in and for the County of Maricopa, application for attorney's fees and costs assigned to the Honorable Judge Mata. This was filed on July 8th, 2024 in the Owens v. Echard matter. It states, Respondent Clayton Echard, by and through counsel, undersigned and pursuant to minute entry ruling dated June 17, 2024, and filed entered with the Clerk of Court on June 18, 2024, Rule 78B, Arizona Family Law Procedures, ARS 25-324, and Schwenger v. China Doll Restaurant, which is a case from 1983. Which I guess is where the China Doll affidavit comes from that we hear about. Hereby files this application for attorney's fees and costs incurred in this matter. Number 1. After an evidentiary hearing on June 10, 2024 on the issue of non-paternity sanctions and attorney's fees, in which the court had the opportunity to consider the parties' papers, arguments, and evidence presented, the court ordered in pertinent part as follows. So notice how Woodnick points out, considered the parties' papers, their arguments, and evidence presented at the hearing. What Gingras is doing when he's filing all these different motions about, oh, that didn't happen in the hearing, he's forgetting that she was taking everything submitted in this case under advisement in making her ruling. And he forgets that part. He's just like, it didn't happen at the hearing. It didn't happen in the hearing. It didn't happen on June 10th. Because she's not just relying on June 10th for information. The court further finds that the petitioner acted unreasonable in litigation. Specifically, petitioner acted unreasonably when she initiated litigation without the basis or merit, without an authentic ultrasound, sonogram, physical examination, and in conjunction with the belief she passed tissue in July 2023. The court finds the underlying petitioner premature at best. At worst, however, fraudulent and made to incite communication, a relationship, or both with the respondent. The court further finds that the filing a motion seeking mediation for the purpose of telling the respondent that the pregnancies were not viable, disingenuous at best, but certainly misleading to the court. If the purpose of the motion was in fact to attend mediation, then the petitioner perjured herself today when she said the purpose of her mediation was to tell respondent about the miscarriage. Either way, respondent likely incurred costs associated with this litigation prior to retaining counsel, and he is entitled to reimbursements of those costs. The court further finds the petitioner repetitively failed to comply with Rule 49, even on order of this court, further compounded by the fact that on the day of trial, she testified that she anonymously sought care at a Planned Parenthood in Los Angeles. While she failed to provide records of any Planned Parenthood appointments, anonymous or under an alias, respondent presumably sought records from all Mission Viejo Planned Parenthoods, as that is where, up until today, petitioner disclosed she sought care. This undoubtedly caused respondent to incur substantial legal fees, attempting to locate records that may or may not have existed in Los Angeles, but now appear to have never existed in Mission Viejo. Additionally, petitioner acknowledged she altered HCG test results in an ultrasound and sonogram, which an ultrasound and a sonogram are kind of the same, but maybe she's talking about a picture versus the video. The court further finds that this provision of ARS 25-324B do apply because the petition was not filed in good faith. The petition was not grounded in fact or based on law. The petition was filed for an improper purpose, such as to harass the other party, to cause an unnecessary delay, or to increase the cost of litigation to the other party. Here, the court finds the petitioner provided false testimony as to the viability of pregnancy in all three cases addressed in the procedural history. And when she says three cases, she is talking about the order of protection that Owens got against Clayton. She's talking about the order or injunction against harassment that Clayton got against Owens, and this case. Those are the three cases. Okay. Additionally, prior to her deposition, petitioner sent a threatening letter to respondent indicating her intention to sue him for $1.4 million in collateral allegations unless he agreed to dismiss this action that she initiated. Yeah, it doesn't look very good for you, especially when you're acting and doing things that your client or your attorney doesn't know about. And you're doing it behind their back. I wonder why your attorneys quit. The court further finds that Laura Owens knowingly presented a false claim, knowingly violated a court order compelling disclosure or discovery such that an award of attorney's fees and costs is appropriate under ARS 25-415. Notice that these awards and costs are not under Rule 26, Gingras. There's no Rule 26 in here. Go somewhere else with that argument. It is therefore ordered granting Clayton Echard's request for attorney's fees and costs associated with the case number. It is further ordered denying Clayton Echard's request for attorney's fees and costs associated with the order of protection and the injunction against harassment hearings referencing the analysis above, which we knew that she was not able to overturn the order of protection. I don't know why he can't get the injunction against harassment fees, but I think because you can't get those fees in those type of situations, each party has to pay for themselves. There is no award of attorney's fees in those types of hearings. It is further ordered that Owens shall pay Echard reasonable attorney fees and costs no later than July 8th, 2024. Respondent and counsel for Clayton Echard shall submit all necessary and appropriate documentation to support an application for award of attorney's fees and costs, including a China doll affidavit and a form of proposed order, by no later than July 29th, 2024. Owens shall file any written objection and a form of proposed order. If Clayton Echard's counsel fails to submit the documentation by July 8th, 2024, no fees or cost will be awarded. Well, they did submit it by then, so we don't have to worry about this. The court shall determine the award and enter judgment upon the review of the affidavit as well as any objections. Number 2, this application for attorney's fees and costs is based on the affidavit of Greg Woodnick, which is attached here too and incorporated here as Exhibit A. 3, respondent fees and costs with Greg Woodnick and Woodnick Law. C, agreement, which fee agreement is attached to the application for attorneys fees and costs here too as Exhibit B. Also invoices itemization for professional service which are signed and attached here as Exhibit C. Wherefore, respondent respectfully requests this honorable court to enter an order/judgment awarding his attorney's fees and costs to be paid at a date certain and to accrue interest if not paid, and any other orders this court deems just and proper. Respectfully submitted the 8th day of July 2024, which was the deadline. Signed by Woodnick Law, sent to all the correct people. All right, so here is the China doll affidavit for attorneys fees and cost. Still in Maricopa County in Owens v. Echard. I don't have a date on this one. Maybe it'll be at the end of this. So, affidavit, Greg Woodnick, being first duly sworn upon oath, deposes and states as follows, that I am the managing attorney at Woodnick Law, and together with Deandra Arena and Isabel Rainey, we are the attorneys of record for respondent Clayton Echard. And y'all all have done a fabulous job. Fabulous job. Everybody should want to hire Woodnick Law. Deandra, Greg Woodnick, and Isabel. That I am a citizen of the United States over the age of 18 and make this affidavit based on a personal knowledge, I am competent to testify as to the matters addressed herein. That myself and all attorneys involved are licensed to practice law in the state of Arizona. So apparently to submit an affidavit into the U.S. courts, you have to be a citizen of the United States and you must be over 18, in case nobody knew. That in light of highly contentious nature of this litigation, amplified by petitioner alleging that one of the attorneys at the firm was complicit in an SA, the office instituted a policy requiring the presence of a second professional during any interaction with Miss Owens or her numerous attorneys. Yeah, nobody is going to be alone with you or your attorneys, because you cannot be trusted and your attorneys cannot control you. That annexed as Exhibit B is the fee agreement entered into by Clayton Echard with the firm for Woodnick Law. The fee agreement is based on an hourly fee rate. That my GW billing rate for this matter is $650 an hour. Boy, are we all in the wrong career. That Deandra's billable rate is $4.25 an hour. Attorney Marcus Reisinger, MR, billing rate is $4.25 an hour, and attorney Isabel Rainey, IR, billable rate is $2.95 per hour. She is the baby doe of this firm, but she has done amazing work here. The firm employed multiple paralegals, MB, SS, EP, who provided assistance in this matter as detailed herein. Paralegals were billed at an hourly rate of $175 per hour. The firm employed a law clerk, LC, in this matter, who was billed the hourly rate of $175 per hour. The total funds that have been expended on this litigation are over $165,000. However, fees that were related to the litigation of respondent's injunction against harassment have been excluded, as the court expressly denied attorney's fees and costs related to that matter. All attorney's fees and costs included here were necessary and reasonable, because you can't just be like putting in things that aren't reasonable just to jack up the bill to get more money. So I think that's the itemized thing is perfect, and it shows a lot. That the court should note that early in the litigation that Mr. Echard received assistance from GoFundMe. These limited funds were appreciated by Echard, but only covered some of the expenses and costs related to Mr. Echard's injunction action, which has been expressly excluded from this accounting. The GoFundMe proceeds did not contribute to Mr. Echard's legal fees paid, incurred, or actually due and owing in this matter, case number. That the fees and costs incurred in this matter through Woodnick Law are as more specifically set forth on the invoice of professional services, which is attached to the application for attorney's fees and costs as Exhibit B. That respondent has agreed to pay and has been charged for said services as set rate as documented by the 2023 fee agreement. That the billing timekeeping information related to this matter was documented utilizing regular billing software in the ordinary course of the firm's business and accounting practices. So they track this with every client. It's put in their billable hours and rates. That all the items related to bills associated with counsel's time therein were made and kept entirely in the normal course of this firm's activity on this case based on time records kept by the person generating the activity or near the time of the services were performed pursuant to the regular practice of this firm. That all the items related to bills associated with counsel's time are true and correct, and each was necessarily expended in the course of litigation of the scope specifically identified by this court in its June 17, 2024 ruling awarding attorneys' fees and costs. The affiant, Greg Woodnick, A, has been practicing law in Arizona for 24 years. B, is the co-author of the Family Law Attorneys Fee Survey. C, is the current chair of the State Bar Client Protection Fund Board of Governors appointee. D, is cooperating counsel to the ACLU. E, was previously appointed by Chief Justice Bales, who is retired, to the Arizona Supreme Court Task Force on the Arizona Rules of Family Law and Procedure, which we learned about through this case, that he was on the committee that created some of these things. So he thinks he knows how that rule works. When Gingras was trying to be like, actually, and Woodnick is like, actually, I was on the committee that decided this rule. Boom. Woodnick is also a former adjunction law professor. He is a graduate school lecturer, current and former. Sandra Day O'Connor College of Law, Midwestern University College of Osteopathic Medicine, Northern Arizona University Department of Physician's Assistant Studies, Yale University Physician's Assistant Program, Creighton University PA Studies, and he is also a CLE instructor, which is, I'm continuing law education, got to get those CE hours. Arizona Chapter AFCC, Children's Service Network, Maricopa County Bar Association, AAML, State Bar of Arizona, Half Moon Education. That attorney Deandra is a former Assistant Attorney General for Protective Services and is a licensed to practice law in both California and Arizona. So Deandra is licensed in the same places as Gingras. I wonder if they have ever battled against each other before, or if they will battle against each other again. Because I will get my popcorn ready to watch Deandra Arena kick Gingras's butt. That attorney, Marcus Reisinger, is an adjunction professor of administrative law in the MLS MHREL program at Sandra Day O'Connor College of Law and is cooperating counsel to the ACLU. Woodnick, Isabel Rainey, is an associate attorney at Woodnick Law, was formerly a law clerk at Woodnick Law. She moved up the ranks when she got her degrees and more experience under her, and eventually I think she could end up being like a partner or something there. That all attorneys, paralegals, law clerks, and staff involved in this matter are duly qualified and experienced to commiserate with their respective hourly billing rates, and that the rates agreed upon and actually charged are customary and consistent with the prevailing market for legal services of the kind. So he's saying our rates are pretty much what everybody else is that does this type of work. They're not astronomical. They're not raised rates just because somebody else is paying. That the attorney's fees and costs incurred for Mr. Echard's representation are reasonable given the qualities of the advocates, the character of the work to be done, the work actually performed, and the result, all in accordance with Schwinger v. China Doll Restaurant, Inc., and its progeny. Words are hard, guys. Words are hard. That the total time expended consistent with this court's minute entry is 356 hours, 0.6. The total amount of attorney's fees and costs associated with this case are $153,592.76. Prepared of the China doll was an additional 1 hour and $650 for a grand total of $650. When you add those 1 hour at $650 an hour. When you add all those 1 hours up, it equals $650. That this application includes not only statutory taxable costs, but also other reasonable and necessary expenses of litigation, all in accordance with the provisions of ARS 25334. That the court should determine that the request of attorney fees, court costs, and expenses itemized herein are reasonable, and thereupon computation should be made in accordance with the following arithmetic formula. Attorney's fees, $148,816. Cost of the China doll affidavit, $650. Total court cost and expenses, $4,776.76. And then when you add all those up, the total costs and fees for it is $154,242.76. Wherefore, based upon the above, undersigned counsel respectfully requests that court enter an order for the reasonable attorney's fees and costs incurred as stated above, respectfully submitted the 8th day of July 2024, signed by Woodnick, subscribed and sworn to before me this day of July by Greg Woodnick. Oh, this 8th day of July. And then it was notarized by Miss Mary Beth. This is the retainer agreement, confidential and privileged. That is December 11th, 2023. I'm writing to confer the terms under the office of Woodnick will represent Clayton, the client. We appreciate your decision to retain this firm in this matter so that we clearly understand the basis upon which we have agreed to represent you. I have prepared this letter. Client's representation. It is understood that our client, for the purpose of representation, is Clayton Echard, and not any of client's individual members, family members, or any other entities. The firm has been retained for services for limited representation in the pending family court case, Owens v. Echard, not including appellate issues, through February 15th, 2023. By signing this agreement, client acknowledges that the scope is limited and that depending on funding. Should funding become an issue, client agrees that Woodnick maintains the ability to terminate the agreement. The firm will not provide tax advice. The fee agreement also does not include appeals taken to any federal or state court of appeals by any party. A separate agreement will be signed if the client and the firm mutually agree to representation in an appellate matter. The firm also does not handle or prepare qualified domestic relations orders or other similar orders required to divide retirement benefits outside of the decree. No guarantees. It is understood that the firm has not made and cannot make any guarantee of success in this matter. We will work diligently and competently to achieve clients' objectives, but we cannot guarantee the success of any matter. Well, you were successful in this one. You all did work diligently and competently. Staffing. I will have primary responsibility for your matter. We also may use other attorneys, paralegals, and litigation clerical assistants where appropriate. Staffing decisions were made by me with the objective of rendering services on the efficiency and cost-effective basis. And then the fees, they listed out all the fees which we went over. The firm requires an advance fee deposit of $4,000 that will be held in a trust account and billed against and will be credited anticipated fees referencing herein. Client has agreed to pay $4,000 at the time of engagement. The firm bills in 1/10 of an hour segment. Fees are charged for such service as telephone calls, sending and reviewing emails, drafting and reviewing documents, legal research, attending and preparing for hearings, and travel to and from hearings and meetings. Statements for services rendered and cost incurred will be emailed to the address listed above during the month following the month in which the service is rendered, and the cost advance charged. All statements are due and payable upon receipt and will be deducted from the advance fee deposit unless client notifies the firm within 10 days of emailing of the invoice that the client has questioned about the statement. The firm reserves the right to notify client that the fee deposit has been depleted and must be replenished. Payment, the firm assumes that the client has given informed consent for third party to make such payments. Okay, so we got that. We got that he's going to be emailed his statements. Client will provide a cost advance of $0. Client's responsibilities. Recognize that the firm cannot effectively represent a client without their cooperation and assistance. Client agrees to cooperate fully with the firm and to provide promptly all information known or available to client relevant to the firm's representation, including providing information documents requested in a timely fashion, assisting in discovery, disclosure, and trial prep, cooperating in scheduling and related matters, responding to telephone calls and correspondence in a timely manner, and informing the firm of changes in client's address and telephone numbers. Did Owens sign something with this client's responsibility? Because I think she forgot that the client has responsibilities to their attorneys when they are retained, because she did not cooperate and give her attorneys all the information and disclose things in a timely manner or at all. Discovery and disclosure. During litigation, each party has the right to request information from the other party, including employment and income records, medical, psychological, and any other health-related records, criminal and domestic violence records, or history, and other information that may be relevant to financial issues and child-related issues, as well as electric items. The process is called discovery. Once again, Owens didn't read this part of her contract. Therefore, every discovery can include electronic discovery. Therefore, everything you post online or through social media may be discoverable. Therefore, it is important to refrain from discussing your personal situation on the internet. It is also sanctionable if you take any action to destroy or delete any potential relevant evidence, including social media postings. Yeah. Owens definitely didn't read this part of her contract if it was in there. If you have any questions about this, please make sure you discuss it with the firm. Electronic communications. We communicate time to time with our clients via mobile telephone, email, and facsimile. You should check that email regularly. We will assume that third parties do not have access to that email address, so you can receive confidential correspondence from us. You should change your email address password if there is any reason to believe that anyone else knows your password and can access your emails. So yeah, make sure that you are the only one that can see the confidential information, so other people can't be logging into it. This is not really a thing for Clayton's case, but definitely during like divorce and child custody cases, if your ex once knew all your information. We retain many file documents and data electronic format only. These documents and data may be stored on a remote secured third-party server hosted through the internet. Collection, termination of engagement, entitled to fees and services completed, reserve the right 30 days more past due, signed Woodnick and signed Clayton. The terms of engagement of the firm as stated below are accepted and approved by Clayton, December 11th, 2023. All right, so we have 12/8/2023. The call with Clayton was to discuss the next steps in review of his draft motion edits to same. Staff with Greg Woodnick and Deandra, and then they did a bunch of different drafts and stuff. Affidavit of non-paternity, punitive father registry, which was an amazing idea. It cost $501 to draft a motion for extended dismissal and expedited, and the affidavit of non-paternity, and to do the punitive father registry. Like, that cost him a lot of money, but it was really smart, so she couldn't say it. Let's see, they have those. Let's see if there's anything else that's good. A lot of calls, staff meetings, finishing touches on drafts. They started drafting of the deposition on December 28th, 2023. And then let's see. Research regarding case law for SMG argument and other legal questions posed by motion to dismiss and staff with Isabel Rainey for inclusion and response. Status and strategy. And then let's see. This is the motion for sanction, response to motion to quash. So that's what they're doing in this one. Received and sent client notice of appearance. This is in January where they're trying to schedule the deposition of Owens. And then we've got non-appearance. Corey Keith is now on the case. Because there was this when we talk about the issues of her not going to her first deposition. And let's see what else. Minute entries, emailing with Corey. Talking about more of Laura's allegations. An email from Amazon regarding spoliation notice. That was interesting. Review and approve amended petition. I was like, what? Pet? No, petition for filing. Okay. So the Amazon one is kind of the thing, and we know Corey Keith is on the case now. And then still talking about getting her to do her deposition. And that deposition stuff cost pretty pennies. I will try to have this linked below if you want to go through it and read it yourself, or you can just pause each screen and go through each one, just so that we have all of it here. This is when they're going to start talking to experts and trying to find some. Draft email to Corey regarding yet another Medium article, because she just keeps those coming. Let's see. Court responder. Final hearing prep. Traveling to court. Research through files, list of names of providers sent to the court per request by Judge Mata. So this is when we saw in the hearing that she gave a list of all the people, which she lied about most of those people. This is where Owens in 2/22/24, where Owens started to claim miscarriage, or they're looking into the claim of miscarriage for her. They have the HIPAA documents that they want. Review disclosed audio provided by opposing party. Getting discovery. They had a call with Mike Maraschini. They interviewed Colin Scanlon, which is an ex of Michael Maraschini's sister, because I don't think Colin Scanlon and Michael Maraschini's sister are still together. And that's still about HIPAA releases and stuff, and trying to get discovery and evidence. They're prepping for the deposition. They confirm the deposition. Corey and staff regarding responding to comments about seal and publicity. Docs reviewed regarding Ron Owens, who posted about pregnancy. And then they had the deposition, and they emailed Smile regarding tampered records. They had an email with Matt Mulvey's attorney, who was victim 1 that we know of, that we found out about in the deposition. Edits to letter emailed to Planned Parenthood Mission Viejo. Let's see what else. More about Matt Mulvey. Email exchange regarding other victims and contact from sources regarding the same. Okay, and we got consult regarding the sonogram, motion to compel, HIPAA release women's care, update email, and this page, second page over here, review the deposition transcript, and then Sarah Navarro, which I believe, I don't know who Sarah Navarro is. Researched Sarah Owens' contact information and prepared subpoena for trial appearance, which they ended up not doing or using her. Rewatch parts of October 25th OOP hearing. They got paid, and drafting and researching for relief from judgment. They got paid $442 to rewatch parts of October 25th OOP hearing. Can you imagine if all of us were paid that? That would cover Echard's attorney's fees if we all got paid that for watching that hearing and rewatching it. Gingras is now on the case. Email with Planned Parenthood after reviewing records not matching claims for Laura. And medical records reviewed. He talked to Gingras. He gave Gingras a Dropbox link and had uploaded documents in it so that the opposing side, Gingras, can have that. Regarding alleged photos, which those photos I think are the July 2023 photos of the blood or tissue, fetal sacs, whatever she wants to call them. Bunch of drafts. Meeting with Mr. to vet research options regarding sanctions motions. Email exchange regarding Elo's postings related to the newest essay claim. That's when she started claiming ARP. 3 emails from David reviewed and staffed, as one was overtly threatening. Call to the Bar Council Ethics Hotline. First draft response to David, but will hold for ethics advice, and an email. And then, of course, Rule 26 sanctions. They had to address 20 million times. Emails from Gingras and review new filings. There was so much that Gingras added to this case. Like, he is the one that racked up the bill. Like, in comparison to things. Review postings online again from Blank, and bar complaint posted on web from Laura and staff. New disclosure statement. Email to experts regarding records received. Email Blank regarding concerns. Escalation. Timelines. Reviewed notice filing and docs from David regarding Gillespie. Email to Clayton regarding the same. I don't know who Fabian Zazuda is. Oh. Call with FZ regarding Gillespie. Info now public. The reply to lunch. Cross-referenced. Review email staff with Rainey. Email to David regarding docs after cross-referencing the information with info already from Planned Parenthood. A buzz. Let's see. Email from Blank with more disclosure without metadata. Email to expert regarding the same. Email from Blank with still no metadata, and his comment, as such, I do not plan on responding to further questions about the photos since my additional discovery into that issue is not, is not proportional to the needs of the case. See Rule 51B1A. Contrary to specific discovery order, email to Neumeister regarding same and staff re how to obtain information if they are refusing to provide actual metadata, which Neumeister was who they were trying to get to look at the metadata and everything from Owens. And Neumeister was also the one that was used in the Johnny Depp Amber Heard case. Depp used him to prove how the pictures line up, and they're the exact same picture. Forensic expert regarding what is needed, metadata regarding missing data on photos, communication with client regarding news stories regarding same, posting regarding case and paternity, research and proposed response for opposing counsel regarding metadata, email with David regarding metadata, and reviewing another screenshot. Call with client regarding police and fraud similar to baseball player in news whose accuser was prosecuted. That was Trevor Bauer. More metadata. Email to Clayton with commentary and regarding police involvement. Email regarding video Blank posted on YouTube. Bizarre tweets and posting staff with MR. Read through more recent postings by Gingras. Like, he's having to pay to look into Gingras's unethical behavior on Twitter. Like, that's costing him money. Postings by Gingras regarding vanishing twins and theories. Forward to some experts. Let's see. Witness Maraschini's attorney, Gillespie, regarding him talking to who may want to interview him. Call with Gillespie, who indicated he had sent the letter to. And then Gillespie and correspondence from Blank just respond to same. Status updates. More work on Echard. Call from Mike Maraschini confirming trial date, and he will be here to testify. Email with Greg after receiving information about his interaction with opposing counsel. Yeah, Maraschini and Gillespie had interactions with Gingras, which we went over on this channel. More about Maraschini. Let's see what else. Emails from doctors. Email to journalist Dave Neal, who apparently received records from LO for copies of the same. I know there's another one that he also, and maybe later on, but he had talks with Reality Steve Carbone. Reviewed more documents regarding tampered medical records. Note to Stormy, who says the records are hers. That is when she stole this lady Stormy's medical records and stories and pictures. Review the records from Planned Parenthood, confirming no July appointment. He had no appointment in July, no matter what date you say. But she also stated June 28th, so that wouldn't cover July. So, I mean, it's just all lies. Email from Gingras regarding Harvey Weinstein. That cost $130 for him mentioning that ridiculous crap. Bait stamps, drafts. Let's see what else. Okay, more supplemental statements. More motions. Expert report came in. Prepare and have issued subpoena. Deuces to come for Maraschini. Call client to discuss response. Call with witness Maraschini. Then call with client. Keep him updated. Isabel Rainey sat in on call with David Gingras. David Gingras believes texts from Michael Maraschini are likely real. Laura is considering her own expert to review Michael Maraschini's laptop. David Gingras is trying to get Laura to agree to a settlement. Why would you need her to agree to a settlement if she's telling the truth, Gingras? If you can prove that she isn't lying. Possibly an underlying mental health condition. Notes on the same. Staff with Greg Woodnick and Deandra. So Isabel Rainey sat in with this and then updated Woodnick and Deandra. And they did not charge for this. For Laura's mental health possibilities, they did not charge Clayton for that. It should have ended there. Because the settlement would be, you admit you're a liar. Call with Mike Maraschini regarding another posting from Gingras upsetting him. Calls regarding new tweet from Gingras that upset witness Michael Maraschini. Email to David regarding the postings. 2 emails from Blink, one of which weirdly includes my name on texts, and no contacts, full staffing with DA regarding developments including these emails. Call with Greg Gillespie. More telephone calls and affidavits. Notes on Owens' inconsistent statements. Withdrawing sanction 26. Pre-trial stuff. And then Isabel Rainey, David Gingras email and ethical compliance duties with Greg Woodnick and write email to David Gingras regarding the same in accordance with Rule 4.4b. Email from blank where he attempts to bully Corey Keith into not filing a notice of candor. Yeah, well, he did anyways. Good for him. And then Matta's ruling. Talk with Maraschini for the upcoming trial. And go over more. Got a bunch of to-dos on this one to get ready for trial. Zoom link sent to Gingras. Revisions. Video call. Communication with Clayton regarding new developments and the posting from Laura and Blank immediately after our set conference where Blank sort of apologized for how things were handled early in the case, but then promptly posted this similar to what happened with the posting of the picture of Maraschini. That was 5:30. Let's see. Extensive reviews and edits for appellate if they need it. Email from Gingras. Promising an appeal, basically. Email exchange with Blank regarding providers and Corey. Communications regarding court's February order. Let's see, what else? Findings of fact that they did right before the case. Maraschini. Let's see what else. Finalize things. Reviewed Owens' points. Prepare the trial notebook. Call with the court, security, and staff regarding options in light of Blank. Letter, email to all regarding arrest, comment, researched, and regarded. That was $520 because of Gingras' threats on Michael Maraschini. Looking at a statute regarding witness intimidation and revision to the letter that was included in that $520. And Gingras' threats. Email with the court regarding Maraschini, $250. Interview and prep with Gillespie. Continue reviewing exhibits prior to correspondence between the parties and counsel, pretrial statements, and begin reviewing deposition of opposing party in preparation for trial. Working on prep outline. Get the link for witness testimony. Coordinating with expert to video appeared. That was Dr. Dean's. Witness prep with Dr. Dean's. Just getting ready for trial. We're just a few days away from trial in these. Prepping, reviewing all evidence. The travel to court for the hearing. Echard's post-trial cleanup draft regarding Echard. Email from Blank staff regarding allegations against the court for impropriety. Call with the Clayton regarding impropriety allegation from Gingras. Email to Clayton regarding the same. Review multiple bizarre tweets from Gingras, including him asking for Venmo donations and comments about it being only halftime. Call with Clayton to discuss ruling. Prep the China doll affidavit. And so forth. All right. Then we have all of the filing fees, the consult fees. On March 14, 2024, cancellation for the deposition. On January 17, 2024, from Maricopa Reporting was $500. Transcript and videographer costs for deposition of Owens, $1,909.65. Transcript costs for the deposition of Clayton, taken on February 2nd, 2024, $532.71. And then you've got the subpoena for Michael Maraschini, and then all the other filing fees. So that's a lot of charges, a lot of things that add up, and Gingras racked up this bill on a lot of things that didn't have to cost somebody money because they didn't need to happen. But his way of acting and her way of acting is actually not going to cost Clayton extra money. It's going to cost them extra money. Well, Owens anyways, for her, this current attorney's behavior. But she picked him. She has nobody to blame but herself. Our quote of the day that we are going to end this video with is, one of the best ways to achieve justice is to expose injustice. And that is what we have done in this case, is we have exposed an injustice to 4 men by 1 woman and a crazy attorney. If you like this video or you want to make sure that you are here for more Owens v. Echard updates, please hit that like button, subscribe if you want, turn that notification bell on. We do offer memberships, we have super thanks, we have all the things, we have merch that's going to be coming out soon. So stay tuned, and I will see you guys later.